We have Heather Burke from the law offices of Heather Burke. We have Stephen Munkelt from Munkelt Law Office, and Jennifer Granger, the law office of Jennifer M. Granger. We're really pleased to have you all here today to represent all of us, I guess, about what the legal issues are, and we're looking forward to hearing from each of you. And so we'll have some presentations from all three of them and then open it up for questions at the end. I think we can have a pretty fluid conversation similar to what the conversations we had this morning. So ask questions as you need or as you think of them.
So this is kind of an age before beauty kind of thing. As you can see from my beard, I'm a product of the flower child and counterculture revolution generation. Huh? So let's try that one a little better. Well, it sounds cleaner anyway. I'm going to try and do a perspective and then bring this into a little bit about the current legislation status and the regulation status, and then Jennifer and Heather are going to have some more details on special aspects or particular aspects of this, and we're all available to answer questions, and we may even pass things back and forth and give you multiple answers to some of them. Back in that counterculture generation was when a lot of people decided to drop out of the regular society, and they were going to return to the land and do a lot of different things. And one of the things they did was go up in the hills and raise cannabis. And as you all know, some of that spirit or ethos may still be persisting in the community of people who are involved in cannabis cultivation and production. Well, pretty much any way you look at it, that was a counterculture, anti-regulatory, and ultimately illegal way of conducting your life. And the way it supported itself economically was initially entirely on what you could legitimately call a criminal or black market. And then for the last 20 years or so, California has been in a very gradual transition away from a completely black market cannabis industry toward what we are now really opening the doors on January 1st of 2018, which is legal commercial cannabis activity. That's going to be a big change. People who have been in the industry operating under the black market rules and black market economy and without regulation, who want to make that transition, are going to find that it's going to be a really big step up and a really major change in the way you conduct yourself and your business and your activities day to day to day. And part of that, a big part of that, is what you've heard from the speakers this morning, which is this is going to look like the best regulated and most regulated agricultural industry in California and perhaps in history. It's going to be regulated more than wine. It's going to be regulated more than beer. It's going to be regulated more than anything. And when you look at, something similar to cannabis like alcohol products, you say, well, why would we be more regulated than alcohol, like wine and beer? Those are agricultural things that turn into this. Well, the difference is that when the flower comes off the plant, it's saleable on the black market. When the grape comes off the vine, it isn't. So the regulations for wine and beer don't have to worry about what happens with the hops or what happens with the grape. They only have to worry about what happens to it after it's processed. So with marijuana, where the black market is very much willing to and has been for decades making a commercial product out of this thing right off the plant, there's a whole additional level or layer of regulation to try and control what happens. And that's where you get one of the things Hezekiah was talking about this morning, which is the legislative motivation to get some kind of unique identifier on every single plant, instead of by doing it in batches and that sort of stuff. With that specific issue, I would expect that will evolve over time, but at the moment it's going to be, we're worried about what happens to every single bud, So we're going to make you identify each plant. We're going to go from there. The evolution of these things is going to be largely legislative, but also regulatory. Regulations fill in the gaps and provide the implementation for the statutory framework. So it always pays to take a look at what's happening with the law, by which we're generally referring to statutes. And as everybody knows, marijuana is still a federal Schedule I drug. There's no recognized legitimate federal use for this plant. And everything that you could do with cannabis, even under California law with a license next year, is illegal under federal law and creates some risk that you could be prosecuted federally. You could have your crop seized, your property seized. A bunch of bad things can happen that way. So that's still one of the risks that's involved in this activity. For the last several years, the actual degree of risk in that area has been limited or reduced by a number of federal initiatives, one of which was Attorney General Holder's attitude towards state regulation of marijuana and the lack of any interest in imposing federal regulation on top of that. And another of which was Congress's passage of what's usually called the Rohrabacher-Farr Amendment, which restricted the use of funds by the Department of Justice and DEA to prosecute cannabis activities that are legal under state law. And that was up for renewal. That Rohrabacher-Farr provision was up for renewal in the budget bill that passed yesterday. Does anybody know whether it was included in the final version or not?
It was, but it has a 1 week.
You think it was?
Yes, for 1 week.
Continuing resolution for 1 week.
Oh, okay.
The amendments will be back on the floor next week.
Okay. So that's one example of things that are in flux and change, and even on the level of a 1 week thing. The federal legislation that's most relevant to today's workshop that's introduced in the House this year is the SAFE Banking Act, standing for Secure Fair Enforcement Banking Act. The idea there being that, as you know, federal law prohibits banks accepting money related to criminal activity, and that makes it difficult or impossible for commercial cannabis businesses to have a bank account, to write checks, to have a credit card, to do anything that's not literally dealing in cash, which creates a number of problems, including a high risk of robbery and other kinds of violent crime. So this is an effort to start the process of trying to amend those federal laws so that the banks can allow legitimate cannabis businesses to do legitimate banking. And that would be a huge thing if that eventually comes to pass. I don't think the chances this year are very good, but at least somebody's thinking about it and working on it. I think Hezekiah mentioned this morning that there's a truckload of bills in our state legislature that are dealing with one aspect or another of the cannabis issues. And one of those, an important one that's intended to try and harmonize the medical MCRSA from 2 years ago with the AUMA from last November, is included as a budget trailer bill, which inspires me to try and give a short bit of civics lesson about how the legislature works. In general, legislation in California has to be proposed and put into bill format in January and February of each year. And there are assembly bills and Senate bills, so they start, each bill starts in one house or the other. Then after a bill is formally recognized and numbered, it's assigned to committees for review. If it gets through the committee process, it goes onto the floor of the House where it was proposed. It's about in April of each year that the first of the bills have gotten through committee and start to get to the floor. If a bill passes in its home house, like an assembly bill passes the assembly, then it goes over to the Senate. And the Senate assigns it to committee, and it goes through review, and then it maybe gets to the Senate floor, and it gets a vote there. And sometimes there are amendments in this process, and when they have passed both houses, a bill might still need some reconciliation before it finally gets a final passage. Then, in August or so, almost all the bills that are passed end up going to the governor's desk. And the governor has until some date in September every year to act on any bill that was passed by the legislature. So that's why sometime in September, if you're following the news, you'll see that the governor signed 150 bills today and rejected 300 more, or whatever the numbers are each given year. Well, in addition to that process, there are a couple of variants that occur. One of them is a bill that's given a number in February, and it deals with jaywalking offenses and increasing the penalties for jaywalking or something like that. That could get partway through the process, and then in maybe July, the author of the bill completely changes it, removes all of the stuff that was in it about jaywalking, and all of a sudden makes it a cannabis bill. That's called a gut and amend. So you've got a bill that's been authorized, it's been numbered, it's got an existence as far as the legislature is concerned, but all of a sudden the subject matter changes late in the day. And then it kind of gets an expedited legislative look. So that's how some late breaking things happen, and that was one of the things that happened in 2015 with the cannabis bills that turned into MCRSA. There were multiple bills in the legislature, and the governor got involved in trying to figure out a way to harmonize everything, and Hezekiah, I'm sure, was involved directly in some of that process. And then I think it was actually in the last week of August or thereabouts, that they all of a sudden had essentially a gut and amend and put all these things together into 3 bills that then got through the legislature in about a week so they could get to the governor's desk. So that's one alternative process. And then another alternative process is one we're talking about this morning with the governor's proposal for harmonizing, and that is the budget trailer bill. When the governor presents the budget, there's always a bunch of sort of cleanup legislation, or at least that's what it's supposed to be. Cleanup legislation for things that were maybe they made typographical errors or things didn't quite work the way they were supposed to, and these things all get attached to the budget bill, kind of like the Rohrabacher Farr Amendment in the federal budget process. So that's today's 5-minute lecture on civics and how this process all happens, but a little bit of an explanation for why, when you ask us questions about specifics, there's going to be many things that we'll say we don't know yet because it's still in the process. Just to touch on a few of the bills that are currently in the state legislature, and just to give you some overview of kind of the topics that are coming up. We've got AB 1652, which requires that there be a report to the legislature by June of 2018 about any additional measures that are necessary to deal with the illegal distribution and transportation of cannabis. That bill's been referred to committee, but it hasn't gone anywhere yet. SB 311, which would affect what responsibility licensed distributors have for arranging the laboratory testing of cannabis, and allows testing for quality assurance purposes, which isn't necessarily clear under present law. And that passed the Senate on 4/20, so it's going to the Assembly now. You've got AB 416. The entire bill consists of one sentence. It says, "It is the intent of the legislature to enact legislation relating to CBD-enriched cannabis." Period, close quote. That hasn't even been assigned to committee. I think it may not be taken too seriously. Anyway, that's just a touch on some of the things that are going on. Then, as everybody has mentioned, Friday we had the the first real rollout of draft regulations for agriculture, fish and game, and whatnot. The biggest bunch of those, at least from the standpoint of a lawyer looking at the regulation of this activity, the biggest bunch of those is the new Division 42 of Title 16 of the California Code of Regulations, which is the Bureau of Marijuana Control. And the California Code of Regulations is the compilation of all these administrative regulatory requirements for just about anything that happens in state government. And Title 16 includes the regulations for a whole laundry list, 41 different categories of occupations and activities. So accountants regulations are in Title 16, barbers, chiropractors, cemeteries, the medical board. There's a whole bunch of stuff that falls under this title. And then up till now, there have been 41 divisions. Now, Division 42 is the Bureau of Marijuana Control. This initial rollout is 58 pages when you print it out. And it would not be useful to try and give you the whole 58 pages. But what I did do was try and go through and highlight a few things that I think will give you some idea of the scope and the requirements that are going to be involved in implementing these medical marijuana requirements. There are several places where the regulations are clear that if you're doing activities under these regulations for medical cannabis, you cannot be also doing anything for adult use cannabis at the same facility, under the same license, in the same location. There's nothing that prohibits the same person or company from having both kinds of licenses, but they're basically saying you couldn't do it in the same place. So that at least as it's existing at the rollout, these regulations are distinct and separate from whatever would be proposed under the adult use law itself. There, of course, is an application process. Applications for licenses can be completed online, and they've got an address in the regulations, and of course, it can also be done in writing. One of the requirement of information to be provided on the application includes all kinds of stuff far beyond your address and the telephone number, including the organizational structure of the applicant, business formation documents, percentage of ownership held by the entity owner, and there's a definition of owner and what percentage. Essentially, anybody with a 20% interest or more is an owner. One category of information is a detailed description of any convictions. And a conviction is defined as a plea or verdict of guilty or conviction following a plea of no contest, even if that conviction has been set aside under Penal Code 1203.4, or there has been a certificate of rehabilitation issued by the court. And then for any conviction, as part of the application, you also have to give a statement of your rehabilitation from that conviction. As you may recall, the statute prohibits barring issuing a license, prohibits them from preventing a license just because you have a conviction for a marijuana felony in the past. But this is carried out in the regulations to give you more detail of what you have to tell them and what they're going to look at. At the time of the application, you have to have documentation issued by your local jurisdiction, certifying you're in compliance with all local ordinances and regulations. Obviously, that is an endpoint for anybody in Nevada County as of today. If they were accepting applications, you wouldn't be able to submit one that would be considered because nobody in this county can have, at the moment, approval of the local jurisdiction. You have to have a valid seller's permit issued by the Board of Equalization. There's an interesting prohibition on members of law enforcement are not allowed to hold a license under this act when their duties have anything to do with the enforcement of the act. It would basically involve all police and sheriffs, among other categories of law enforcement. If the applicant for a license does not own the real estate where their premises is going to be, whether that's a premises for cultivation or distribution or processing or whatever it might be, if you're not the landowner, then you have to have information with your application from the landowner. This is different than our ordinance problem, where they're trying to get an owner to sign a statement that could be used against them in federal court to show that they've given permission. But it's from regulatory purposes here. You do have to show that the owner isn't going to be kicking you out because you're doing this stuff. There's an interesting thing I hadn't thought of, which is that if you happen to be a tribe, federally recognized tribe or other sovereign entity, you have to give a waiver of sovereign immunity, so that Indian reservation-related cannabis licensee applicants are going to have to waive their protection and immunity from the enforcement of California law and agree that, yes, anything that happens here under this license can be handled under California law. There is a priority review for people who were in compliance with local regulations by January 1, 2016. Most of you recall that from when the bills originally passed. And of course, again, that doesn't apply to anybody from our county. But evidence of good standing with your local jurisdiction at the time you make an application will give you some basis for an expedited review process. Let's see. One last thing, I've been asked to kind of wrap this up a little bit for this part, but one thing to be aware of, if you're planning on applying for a license, in addition to the fact that these regulations are going to require setting up systems to be doing recording of information and reporting of that information on a regular basis, setting up those systems is going to be a critical part of anybody who wants to actually obtain a license and function as a licensee. But licensees are not required to meet testing requirements and many of the other regulations until 180 days after they're licensed, or December 31st of 2018, whichever is sooner. In other words, the regulations are recognizing that if you have been conducting cannabis activities and now you're getting licensed, there's a transition period where you may not be able to meet all the requirements instantly. You have a kind of a rollout period of either 6 months or getting it together by the end of 2018, whichever is first.
Hi, I'm Jennifer Granger. Steve and I met Friday and were trying to figure out how to divide up the topics for our panel. So I chose the Nevada City Dispensary Ordinance. And I know Heather has worked on a PowerPoint presentation for her aspect of the presentation today. So I'm going to be pretty brief. I basically just pulled the ordinance and looked at it. But just briefly, Nevada City itself, which is, so each jurisdiction can come up with licenses for medical marijuana businesses or commercial activity moving forward. So Nevada City is the first entity in our county that actually sat down and promulgated a license. So that's exciting news. So Nevada City is going to issue one dispensary license, and if basically, if that goes well, they'll consider issuing up to 3 in following years, at least for now. So it's an exciting first step. My understanding is that Grass Valley City Council is also interested in issuing a dispensary license. And at one point, I think they were pretty proactive on that. But my understanding is that they are not presently considering a dispensary license, but are kind of sitting back and waiting to see what happens with Nevada City. So it was April 12th, the City Council voted to license 1 dispensary. The applications are going to be available 60 days, so sometime mid-June. A lot of the requirements for the dispensary are, when Steve just was talking about the regulations just that have been promulgated for cultivation licenses, a lot of it is similar. There's a pattern with all the different license types. I mean, there's going to be extensive record-keeping requirements. There's going to be extensive security requirements. I was interested to see that there's going to be a lot of, they're going to have to make available to law enforcement names of patients, name all the collective information, members of collectives, members of patients, all of their identifying information is going to be available, and it's just interesting. So it's a lot of interesting things going on here. The ordinance itself, there's an application process. There's going to be a matrix of criteria that people are going to have, that the city is going to review to determine who they're going to choose as the applicant. The top 3 applicants will have to submit, will have to go before the city council, and the locations they've chosen for the dispensary, people who live in that area will be have to be notified so they can come to the city council meeting and give their opinion as to whether or not the dispensary should be permitted in their neighborhood, so to speak. I happen to live about a block away from one of the sites that does qualify under the zoning requirements. And just as a personal anecdote, I know that my neighborhood is very divided on whether or not they want a dispensary in the backyard. Some of my neighbors are like, great, I'm stoked because I'm going to put up a lemonade stand across the street. And then my neighbor who's retired from Robinson Timber is like, no effing way in my backyard. So it'll be interesting moving forward how this works out. But it's exciting, and knowing the cannabis community the way I do, I am totally optimistic that it's going to work out and it's going to be a positive thing. And I think it's a great first step that Nevada City has taken, and I look forward to more licenses in the not so distant future. So.
Thank you. Jen and Steve, we're really lucky to have these two. They probably get bugged by me calling them and asking them questions, but nobody has a better sort of ability to remember statutes and codes like Steve does. So having his first take at the regulations, I think, is a big honor, and we're really lucky. And thank you to Circle, to Rachel and Caleb for organizing this event. This is a wonderful event. Many communities don't have this. So I think we should give Circle a round of applause, too. If you have a question on what is on the slide, please just stop me now because we might not go backwards. As I've been telling a few people already today, too, I've never done a PowerPoint presentation before, so I'm really proud of myself. And I don't even have PowerPoint. I did it in the cloud and then downloaded it, so I've never actually seen it on PowerPoint yet. But Google Slides, it's comparable, so whatever. So I'm just going to give a quick overview of the growing season in Nevada County, some of the laws that you need to know, and we can click to the next one. Most people who have heard me speak before hear me talk about the 3 tiers of law that anybody in cannabis cultivation needs to be aware of. One is federal law, one is state law, and one is local ordinance. I'm going to see if I can use this pointer. How do we do it later? Federal law. Federal law, they can arrest you for cultivating and distributing cannabis. There is no defense there, really. There are some theories out there, hemp and some other stuff, but the gist of federal law is that they can arrest you, there's no defense, and the punishment depends on the quantity that you distribute or cultivate. For state law, there's two ways that you can cultivate cannabis legally in California. One is Prop 215. Proposition 215 has been modified by SB 420 and now modified by the Medical Cannabis Regulation and Safety Act. And then the second way is Prop 64. Right now, Prop 64 allows personal cultivation only, but no commercial cultivation yet for Prop 64, but we're moving there. Local ordinance. Local ordinance, they cannot arrest you. That's the 2015 Kirby case, but they can cite and fine the hell out of you, which is what Nevada County is currently doing via their interim ordinance. It's a very long interim, a 2-year perhaps interim, and there's some massive fines associated with that. So next slide, please. This right here is sort of a breakdown of the 3 different types of law. I don't like the pointer, I just like the point. So the thing to be clear with is that there's 3 different tracks of state law legality. The Compassionate Use Act, that's CUA, that's Proposition 215 from 1996. Proposition 215 and then later modified by SB 420 in 2004 allows personal cultivation, caregiving cultivation, and collective or cooperative cultivation. Now, after MCRSA came out this concept of commercial activity, and so the collective or cooperative can encompass commercial activities such as a dispensary. Obviously, that's quintessential commercial activity, but it also allows group grow situations, which would not be commercial in sort of a generous understanding of what commercial is. It does require collectives and cooperatives to be formed. They must be comprised of valid California cannabis patients, and any financials must be run in a nonprofit way. The sort of second way that we're moving towards is MCRSA. Can you click that one more time? I think there's a little, yeah. So the arrow pointing down, this is where we are. Everything that we're talking about, we're moving forward, but we're moving forward piecemeal. We're not there yet. We are still modified by SB 420. When law enforcement comes into our gardens, they are still doing an SB 420 check. Do you have a collective or cooperative? How many scripts do you have? So the whole local permit thing, in particular in Nevada County, we are not there yet. So MCRSA, where we're going, let's see if I can figure this. Okay. So here's where we are. Here's where we're going. It allows personal as well, caregiving as well, and now it limits those to 100 square feet, and for caregiving up to 5 patients. I think we'll see that overturned at some point. Caregiving is now, commercial activity now is clear. It's either commercial or non-commercial. So the commercial activity requires the local permit and the state license. Steve talked about the regulations that are coming for the state licenses, but we still haven't even gotten to first base in Nevada County yet. So that's where we're trying to get. And then we're moving over here maybe at some point, but I don't know if Nevada County is going to go Prop 64 when they do give permits, but we'll see. Okay, we can go to the next slide. So here's the changes between last year and this year in Nevada County. And I think I tried to get fancy here, but I'm not very fancy. We can click it one more time. Yeah, look at how fancy that is. And so the big change is the fines. Nevada County Code is $100 per day per plant for all code violations. There is a lot of gray area here. The code says still in one place that they have to give you 5 days to abate, but their notice to abate says immediate. There is a government code section that says they have to give you a reasonable time to correct, but the code doesn't give a reasonable time to correct. But so the plain language of the current code still says $100 per day per plant, and for any other violation. So a lot of times if people have 10 plants over, they'll have $2,000 in fines, one for each plant, and then one for every other code that is broken as well, including like setbacks and whatnot. Commercial cultivation is banned. So even if you had 25 plants on a 20-plus acre parcel that was zoned ag, it is still not allowed to be commercial, which means they are allowing you to have your collective or cooperative max out, but they are not allowing that cannabis to be entered into the stream of commerce. So no matter what, anybody who's growing, even if they have the appropriate plant number, They are out of compliance if they're making a living off of it. However, they cannot immediately cut your plants unless two things. One, there was an immediate threat to the public health or safety. That's the same as last year, this year, or cultivated in violation of state law. That's why we went over state law, because if you are not complying with SB 420, the collective or the cooperative statute, they can now cut you down under the ordinance. So Prop 64 made illegal cultivation a misdemeanor. Actually, that's the next slide. Why don't we go there? Proposition 64 has passed since the last time we were here. It made illegal cultivation a misdemeanor unless there's an environmental crime. They have a general sort of catch-all environmental crime, intentionally or with gross negligence causing substantial environmental harm to public lands or other public resources. Other water code violations that will make illegal misdemeanor cultivation a felony is illegal diversion of water, discharge of waste in a manner that could affect water quality, discharge of waste into an injection well without a permit. We can go to the next slide. If the cultivation, happens in a way where the import or export of an endangered or threatened species, I don't know how that would happen unless somebody's selling like special lizards or something at their garden site. I'm not sure how that would happen. Yeah. Possession of migratory non-game bird, disposal of any substance that is deleterious to fish, plant, mammals, or bird. This is a big one right here that we'll see if we do have, in addition to the illegal diversion of water, illegal cultivation can also be a misdemeanor or a felony if you're harming the earth. And you know what? I agree. Disposing of garbage within 150 feet of a high water mark, obstruction or diversion of the natural flow of any body of water. That is going to be a big one. Next slide, please. Violations of the penal code. So knowingly causing any hazardous waste to be deposited onto any road, street, highway, alley, railroad right-of-way without the permission. I mean, this is basically like tossing butane cans on somebody's road. That's a felony in and of itself. However, if they were to say, see that on your road, that would make any plants on site a felony as well. Disposal of waste at a facility that doesn't have a permit, handling of waste in a manner that could cause a fire or serious injury, or burning or incinerating hazardous waste. Okay, next slide. Okay, so those are scary things, right? Like when we're talking about them, it kind of gives that yucky feeling in the stomach. Like, don't be that guy, don't be that gal, right? You don't have to be. And I call it a soundbite grow. Those, and I've called them for a long time. A lot of times, even when people do have the appropriate recommendations, they are following SB 420 in an appropriate way, in that they have enough scripts in their informal collective and all financials are being run in a nonprofit manner. They can still be arrested if the sheriff can take a photo of their garden and put it in the union. And it's ugly, and it makes people in our community say, yuck. Right? And so keep the garden clean and grow as organically and naturally as possible. Understand where your garden is situated in the greater landscape. A lot of times I tell people, yeah, this land is your land, but it's our land too. There's a song about it, right? So know where you are in relation to the water. Know where you are in relation to your neighbors. A lot of people are growing on these tiny half-acre parcels, and they're way too close to their neighbors. It's inappropriate. Know your water board tier. That was the last panel, an excellent panel. You should know not only your tier and what's required of your tier, but also you should be now, today, following and keeping with your medical cannabis paperwork, your best management practices manual from the Central Valley Water Quality Control Board. My office right now is in full water board sweeps. We are making sure that all of our established clients understand their water board, understand how their garden is situated in that way. So if you don't know it, you should. And if you're my client, you're knowing it. Okay, so I think the last slide is next. Be kind to law enforcement, but know your rights. Law enforcement, particularly the guys who are on, or guys and gals, but mostly right now it's guys, on the marijuana abatement team. They are good people that grew up in this community. Please do not make it a safety hazard. Please be kind to them, but you don't have to allow them entry. Being kind, you can say, I'm sorry. I'm not comfortable letting you on my property without my attorney present, right? If they're already in because of a warrant, then you don't say anything. You say, I want my lawyer now, please. And then I always say, let your paperwork do the talking for you. Most people have to talk because they didn't post their paperwork right. So do what I call your due diligence. It should be there so that any questions you can point and you can say, I want my lawyer. Thank you so much. I appreciate everything you do for the community, but I need my lawyer. They are still going to be going hard this season. So everybody needs to stay safe, take care of your brothers and sisters, and have your paperwork posted. That's all for me. Sometimes I have a whiteboard in my office, and so I'll draw like a picture of a plant, and I'll draw like 2 eyes, and I say, once one of these eyes hits a plant, the other eye should hit some paper. And so what does that mean? It really depends on how you are organized, So for indoor growers, then it should be somewhere right at that same point when law enforcement knows that there's a cannabis plant. Whether it's when they open a door, or whether you're entering into, let's say, a garage and there's a door or a room inside the garage, I would put it sort of on that room. For outdoor gardens, I like to have it posted on some kind of board near the garden. And so when law enforcement comes up, if they can see a garden from the main road, they should see that there's some board that has the appropriate information as well. And then for greenhouses and depths, it kind of depends on what the structure is. Don't make it hard for them, and it should never be inside the house. It should never be in a drawer. I mean, it should be there too, but you should have a copy always on site. Yes, so I make all of my clients keep their water board best management practices manual with their collective or cooperative documents. So now you have your collective or cooperative documents, you have your number of scripts, and you also have your water board. You just pop it right in that same binder or post it on that same board. But the water board does require you today to keep a copy of the best management practices manual on site. And the link was on my PDF, but I think I heard Trey say earlier that you Google Central Valley Water Quality Control Board and the word marijuana, and the marijuana order will pop up. It's attachment A. If you need it, call our office. We're happy to send the link out. Generally, it depends on the structure. Some people now are forming LLCs where their operating agreements run in a nonprofit manner. I think if law enforcement today sees an LLC, even though it's technically appropriate under the collective or cooperative statutes, that they will probably arrest you or at least give you the citation, and then you'll have to go prove to a judge why you can have a nonprofit LLC today. So I think the less that you have on site that is sort of non-traditional paperwork, the better. So certainly marijuana recommendations are sheriff's arrest if there are not enough scripts to cover the plant. So we see a lot of these, hot shots from the Bay coming in, and they have their pooling agreements or their sharing agreements, and the sheriffs will arrest you if they see that generally. They want the scripts. Is that legal? There's a difference between what we can prove later in court and what would get you arrested.
Well, the safe harbor rule is 6 plants per patient, but you're allowed to cultivate and possess what's reasonably related to your medical marijuana condition. So a lot of people have 99 plant scripts, and I always say, well, 99 plants, do you think really you would use that? I mean, maybe it's some rare Himalayan type of marijuana plant where you get 0.5 gram per plant or something, then 99 plants would be reasonable. But if you have 10-pound plants and you have 99 of them, it doesn't pass the jury test. yeah, technically it's okay, but if you have to go in front of a jury and convince a jury that you have 99 10-pound plants for your personal use, probably not going to fly. So I always try and tell people to use their common sense. You know, if you have 20 patients that you're growing, then in your collective, how many plants is reasonable? But then again, you know, if you're part of a collective in the Bay Area and you have 1,000 members in that collective, but yeah, it's just have enough. Just keep the plant to patient ratio reasonable and use your common sense.
No, there's no residency requirement associated with the recommendations and where the cultivation takes place. There is a restriction for the patient exception, where you're the primary caregiver. There's a primary caregiver jurisdictional or geographical thing, but hopefully nobody is trying to operate as a primary caregiver, because the requirements for that are almost impossible to meet. So it's not a very safe place to be.
A lot of organic farmers in the community kind of wave the trail as far as organic and best practices used on the farm. Is the state legislature concerned at all about the heritage farmers, or is it just opening up this legislation to capitalism?
Well, the person who's actually doing the lobbying down there is Hezekiah, but that's why we have this cottage grow category, which was added into the mix, was that the industry representatives interfacing with the legislature said you really need to provide something for these folks who have been doing best practices and are going to continue to operate on a relatively small scale. So it's in the mix, but it's, you know, anything out of the legislature is going to be partly affected by the pressure from different lobbying interests. Then once they lay down the ground rules, your regulatory people are going to be actually more responsive, probably, in terms of getting regulations that cover your base.
One thing I also want to say about the heritage farmer is that in addition to what's happening in Sacramento, in giving us the cottage cultivation license last year, which was a big deal, we're moving into even the cottage consumer. I mean, the cottage cultivator is operating in a capitalistic economy. That's the economy of the United States. We're not a communistic economic system, and some of the others, I'm not even sure what they are, but Steve would know. Socialism. We are our system, economic system in the United States is capitalism. And it's what I call like a hyper-aggressive capitalism as well. And so no matter how big or how small the license types are, that's the system we're living in, which is why there is a movement now for people to start to become ag cooperatives, so people can band together. That's why you're hearing people talk about marketing and branding and all this other kind of stuff. That's sort of a popular in the discourse around cannabis right now, and that has to do with the fact that consumers still want heritage farmer-grown cannabis. And so it is going to be really difficult for some of those heritage farmers to survive in an entirely different world. Those regulations that Steve was going over, it's a whole new world out there. And so there's going to be some shape-shifting. And those who can shape-shift will probably be okay. And those who can't are going to have a harder time surviving.
If I could just add one thing, kind of backing up to what Heather talked about just a moment ago. We haven't gotten to the commercial licensing place yet. So for this season, moving the next few months, we're still in the collective world. So just like Heather was saying, and if you show your LLC paperwork, that's not really relevant at the moment. So people are forming business entities with the idea of being in a position to apply for a license in the next phase. But right now, presently, in this season, we're still in the collective medical marijuana world. So just to make that clear, I think that's an important distinction that sometimes gets lost because we're all so busy thinking about how do these regulations work. Right. Well, so once they issue the first license, which could be, supposedly it could start as early as January 1st, 2018, but assuming maybe it's 2 or 3 months after that, then we have a year. So well, we don't really know, but I'm assuming that everyone who is growing collectively, just like now under SB 420 and what we all know, what we all understand what it means to grow as a collective, that will continue. But then when that year ends, you will no longer have a defense to growing more than your personal use amounts unless you have a license. So, you have this season, maybe, and then probably next season to grow as a collective. And then after that, there are no collectives. So you'll have to have a license in order to cultivate more than your 6 plants. So it's a big change.
But you don't know that Nevada County will allow.
Well, they are allowing 6 plants indoors, not outdoors. So right now, everyone can grow 6 plants indoors, but not outdoors unless you comply with the ordinance. I mean, well, it depends. It's kind of a gray area. I mean, I always consider a greenhouse indoors, but it kind of depends on what the greenhouse looks like. And now, under the ordinance, there are lots of different rules on what it means to be a greenhouse. So, I mean, generally, the Nevada County Ordinance is very, very restrictive. It's pretty hard to grow as a collective and be in compliance with our ordinance. But moving forward, there is this new group that's meeting to try and come up with a new ordinance and licenses for Nevada County. So it's possible that moving forward after the season, probably not this season, but we will have a more reasonable ordinance and we will have licenses.
Slow and steady wins the race. So just pick whatever the next goal is and complete it. Pick whatever the next goal is after that and complete it. Make the goals small. Understand your water board tier. That's easy. Then what do you need to do depending on your water board tier? Then what do you need to do when you need to think about perhaps your corporate formation or taxes? What do you need to do, next? And I really do think slow and steady wins the race, even for attorneys, even for the legislature, people who are super sophisticated in highly regulated industries. It's a lot for them. So, don't try to take it all on and understand it all in one 1-hour seminar with 3 lawyers. Just pick one task and get it checked off.
Well, we've all dealt with this many, many times, but Steve,
Well, search warrants are a criminal tool, okay? So if the Nevada County Ordinance Enforcement Team gives you a gate notice that says, hey, we'd like you to contact us to arrange an inspection, that's not a criminal investigation, okay? And I'm not personally aware of, and you guys can tell me if you know of one or two, but I'm not personally aware of any time where somebody has not responded to the gate requests for a contact, and they said, no, I'm not going to contact them, I'm just going to blow it off. I don't know of any time when that's led to a criminal search warrant. So that, and then the ability for law enforcement to get a criminal search warrant was affected significantly by the Adult Use of Marijuana Act, because you can get a search warrant to investigate any felony offense, but only certain misdemeanor offenses, and the marijuana offenses are not included. So they'd have to have far more than just an idea that there's marijuana on the property to get a criminal search warrant at this point. There is a different kind of court authorization they could seek for enforcement of the administrative rules under the county ordinance, but I don't know of any time they've gotten one. Do you? You know one or two? Well, that was after an inspection, though, right? Yeah. So collectively, we don't know of anyone who's seen an inspection warrant issued by the court to follow up on a gate notice or a refusal to allow them to inspect. There are a couple of cases where there was an inspection and then the person did not self-abate and they got an authorization from the court to go in and take the plants out.
Three types of warrants now: an inspection warrant when they've never been on the property before and they want to inspect. That's what we're saying. We haven't seen them use yet. This is precisely because of the difference in last year's ordinance and Prop 64. This year they will be relying far more heavily on the inspection warrants, I am presuming, because they don't have the ability, like Steve said, to get felony criminal investigation warrants anymore because of Prop 64. Then there's also an abatement warrant. So after they've come in, there was a citation. A lot of times people will just allow them to come on the property. Don't do that. So particularly if you're out of compliance, I never understand why people do that. Like hey, we want to come do an inspection. Well, I'm 200 plants over, but sure, come on in and check it out. No, you say, if you meet law enforcement at the gate, you say, I'm happy to set an inspection at a later date, but give me your card and I'll have my attorney contact you, or I'll contact you within a short period of time. Something like that. It'd be really nice. And get their information. And then also, yeah. And then also, in addition to the inspection warrant, the inspection warrant and then the abatement warrant, they can get a criminal search warrant. But as Steve said, that's a tool they don't have this year. So it'll be really interesting to see how it plays out this year.
Don't they have access to fly fishing game without a warrant? If they can see a crime, an environmental crime being committed, they have a responsibility option, which allows them to pursue it. So if they can see an environmental crime, especially from wherever they're at, they can come on with that.
Right. Whenever you're dealing with a potential felony violation, then you're back in the traditional marijuana search warrant situation.
But a lot of the gate notices, they can't see the plants. They're just hopeful that there's some on there, or they've done aerial surveillance. But from the road, usually it's not that they see a bunch of plants over there. And sometimes they just blanket neighborhoods. It seems kind of random. Well, it's a good thing to have a conversation with an attorney about, but whether, there's a risk and benefits to ignoring or to addressing. Yes, or it just depends on every situation is unique. So, it's kind of hard for us to sit up here and say, oh yeah, go ahead and ignore it. Nothing's going to happen. So.
I just want to say one thing before. We're going to be answering questions outside. There's another panel that's super awesome that's going to be next, and I want to see that. So I might stay for that and answer questions after. I'm hopefully Steve and Jen will too. But if you're following the water board rules, Fish and Game will not be spotting a crime, right? So go follow those rules. And then we'll answer more questions outside.
And thank you so much, Heather, Jennifer, and Stephen.